I was introducing myself. My name is SOULÉLIAC, Director of the International Affairs Department of the Paris Bar Association.
Et le barreau de Paris, qui compte 34 000 avocats, c'est un barreau qui s'engage sur plusieurs fronts, et notamment la défense des conditions d'exercice des avocats, la lutte contre l'impunité, la protection des victimes et la défense de leurs droits fondamentaux. Tous ces engagements s'inscrivent dans une vision globale de la justice qui vise à garantir que les crimes les plus graves, comme les disparitions forcées, ne restent pas impunis et évidemment que les professionnels du droit puissent exercer leur mission.
The application of the universal competence, we will detail this today, faces several obstacles. I'm going to mention 4 legal obstacles because they could be related to complex national legislations, restrictive as well, or non-specific implementation of international obligations, challenges, practical challenges as well, such as the difficulty to access evidence or to have efficient cooperation with jurisdictions and the different authorities involved, but also diplomatic tensions because the implementation of universal competence can bring along reluctancy by states involved who can also consider these actions to be an influence in their internal affairs. And the fourth I will mention are the threats that will lie on the attorneys, defenders of human rights, and in the exercise of their mission within the framework of universal competence specifically, and of course, in the framework of enforced disappearances. I would like to use this opportunity to remind you, I know there's fewer minds of attorneys and lawyers participating in the session, that the Paris Bar Association has a program, the big program, specifically aimed at lawyers, and it allows to welcome lawyers who would be threatened during for media attention for 3 week stays and also 3-month stays so that they can just relax. It is not a training stay, but rather a relaxing moments for them, truce moments, and some lawyers who are working in these cases, enforced disappearances cases, can benefit from this program. That's why I wanted to mention it here today with you. So, despite these challenges, there is progress in universal competence. There are 2 recent cases I will mention. In Switzerland, on the 15th May 2024, the Federal Criminal Court condemned the former Gambia foreign minister for crimes against humanity. This is a historical decision on the basis of universal competence that shows that no shelter is possible for serious crimes, even when it's done outside the country where the crime is perpetrated. And in France, on 6th of June 2024, the appellation court in Paris held a Syrian case with the non-applicability of functional law in the case of international crime. This is a very significant stage, and remember that the authors of enforced disappearances or other violations of human rights cannot subtract to justice, revoking their prior statute or office. Today, we will have experts here with us, well-known, internationally well-known experts, professionals with vast practice and experience, but also the voice of victims who will share the different obstacles, solutions, best practices, and what they have been experiencing. Thank you so much for your attention, and I'm really looking forward to hear to to our speakers with their analysis and recommendations. We will start with our first speaker, Grażyna Baranowska, international jurist, whose commitment is admirable. Grażyna has experience in essential topics such as enforced disappearances, but also cross-border violence or memorial law. Since 2022, Grażyna is a member of the UN Working Group on Enforced and Involuntary Disappearances, where she currently holds the vice chair. Also, a professor of law and human rights professor in Friedrich Alexander University in Nuremberg. So, Grażyna, for starters, could you please talk about this situation, the current situation, because we know there's a growing use of universal competence, and at the end of the day, we have very few cases related to enforced disappearances. Why is that?
So thank you. Thank you, first of all, to the Paris Bar Association for hosting and sponsoring this panel. And we've heard already on previous panels today how of an important topic universal jurisdiction is today. And I feel very fortunate to be on a panel with a lot of practitioners who will be able also to say more about individual cases and share with us expertise from practice. And from our experience in the working group, I wanted to point out two elements that are particularly making it difficult for universal jurisdiction cases that we have looked into so far, and I would love to hear more from the other panelists also about it. So firstly, on a very basic level, for those that are not lawyers here in the room, universal jurisdiction cases are cases when in one country a perpetrator is prosecuted for crimes committed in another place. And what exactly triggers this persecution depends on domestic law. So in every country, this triggering can be obviously very different. Why are enforced disappearances such a difficult violation to be prosecuted, not only under universal jurisdiction? And the working group has in the past already adopted standards showing countries how to investigate enforced disappearances domestically. There was a study adopted in 2020. And it already shows a lot of challenges. And those challenges are even heightened in the context of universal jurisdiction. And the first one that has already been mentioned more than once in other panels is the definition. If the state does not adopt a definition that comes from human rights law that really allows for prosecution, then this will not occur. And this is really a basic information that is really difficult to address and discuss with. And then the second one is evidence. And we do know that evidence is an issue at all domestic trials and on universal jurisdiction trials. When we think about a crime being committed, a human rights violation being committed in another country, to collect this evidence and bring it in front of a court in another country, that becomes even more of a challenge. So we would see that as two reasons why there might be not so many universal jurisdiction cases in coming yet. And the interesting thing I want to share is that looking at how difficult it is, how few cases there are, what we started to do as working group is to reach out to NGOs and litigators that stand behind new cases on universal jurisdiction, where we thought that there might be reason to also include enforced disappearances, but they did not, to ask them why did this not happen? Why would they not ask for enforced disappearances to be included? And in the contact that we had so far established, most of them said it's for strategic reasons, that they believe to be more successful with other crimes than with enforced disappearances.
Thank you very much. I'd like to give the floor to Philippe Grand, founder and executive director of Trian International. So, Philippe, you are a passionate lawyer, fighter since the beginning, since the teenage years of human rights, with a very long-lasting experience in the field, always fighting for the academia perspectives as well. I do have a question for you. I'd like you to tell us, I told that, of course, that there are many lawyers here, but non-legal people in the room. How can you explain the universal framework for us to understand what is that? What is these universal competences? And how is articulated and how it really works? You have the floor.
Comment ça s'articule, comment ça fonctionne. Je vous laisse la parole.
Okay. Thank you very much. Hello to everybody. Let's see if we have some music in the background. You might all remember this day in October, at least for those who are not that young here. On the 16th of October 1998, General Augusto Pinochet was arrested by Scotland Yard in London. This was the start of the universal jurisdiction movement, the first real case where we thought there could be a real impact. Universal jurisdiction is a legal concept grounded in international law. I'll come back to that, give a few details. But it's been around for quite a long time. But until really the Pinochet precedent, there were no clear cases. Since then, in the past 25 years, there's been a number of cases around the world, mostly focused in Europe, but sometimes also in other countries, where countries that do not have any link to the crime scene, to specific crimes under international law, allow themselves to investigate and prosecute perpetrators of these crimes. If you take a look on our website, we have a map. It's called UJIM, Universal Jurisdiction Interactive Map, where you could see all of the cases concerning universal jurisdiction that have unfolded in the past years before a number of various jurisdictions. If we're just counting the trials that have taken place, I think there's about 100 of them. So it's more than we think. And there are, I think, about 250 cases in total, with quite a number currently ongoing with investigations. So universal jurisdiction is, as I mentioned, a legal concept. It has its roots in international law. I'm not going to go into too many details, but basically it applies to certain categories of crimes, the worst of the crimes, so genocide, crimes against humanity, war crimes, torture, and for us, of course, enforced disappearances. For enforced disappearances in particular, it has a very clear basis in the 2006 Convention. If you take a look, if you have the text, I don't know if that was distributed. Article 9 mentions an obligation of states to establish their jurisdiction, to allow themselves to undertake criminal investigations and prosecutions based on a number of criteria. Of course, when the enforced disappearances took place on the territory of that state, but also when the author, the suspect of the acts, is a citizen of that state, and even possibly when there are victims who are citizens of that state. That's not universal jurisdiction. Universal jurisdiction is the next paragraph, paragraph 2, which says when there's a perpetrator present on the territory of a state party, that state party must, first of all, establish its jurisdiction, meaning having laws that allow for the prosecution of enforced disappearances and that allow for the opening up of cases when there's no link to that country. And then on Article 10 and 11, you have the obligation of states to exercise concretely in specific cases that jurisdiction. And the requirement is the presence of the suspect on the territory of the state party. Those obligations are quite clear in the convention. So you might think, okay, all of the states have adopted adapted their criminal law, have given themselves jurisdiction, and as there are quite a lot of cases of enforced disappearances around the world, and probably quite a lot of suspects traveling around, there should be quite a lot of cases that have already been investigated and prosecuted. The fact is, Unfortunately, that the situation is not as rosy as that. To my knowledge, there is only one case that went to trial so far. We mentioned that a case in Switzerland, in which my organization was also active. To be fair, there has been a number of other trials that have adjudicated the crime of enforced disappearances, but in context of crimes against humanity or in context of war crimes, and that has a different legal basis in international law. But if we just apply the Convention on Enforced Disappearances, there seems to be only one precedent, of which I will maybe talk about a little bit later. Last point, maybe just to explain a little bit how it works or how it could work. For me, there are at least 4 elements that are really important for universal jurisdiction cases to go forward. The first one, we've mentioned it, is a clear and sound legal framework. States must do the necessary to implement the obligations of criminalizing correctly enforced disappearances and giving themselves the possibility to use universal jurisdiction. That's the first point. The second is giving resources, financial, human, but also expertise to their investigators, to their prosecutors. We see in countries that have established what we call war crimes units, specialized units to deal with these cases, that they are the countries with the most results in terms of universal jurisdiction cases. Third is international cooperation. The witnesses, the victims, the evidence is generally not in the country where the crimes are being prosecuted, so you need to have some sort of international cooperation. And the fourth element is also one of cooperation. It's the vital role of civil society organizations. I think in most, if not all, of the cases of universal jurisdictions, you have civil society, NGOs, victims groups involved at one point or the other. They are the ones who locate the suspect and inform the authorities. They are the ones who investigate and document the crimes. They are the ones who support and defend the victims in court. They are the ones who make the trial accessible by doing outreach, go back to the affected communities, etc. And that is vital, but often overlooked, the role of civil society.
Thank you very much, Grażyna. I'd like to ask you something about this working group. You talked about implementing a study about universal skills when dealing with forced disparitions. Could you talk a little bit more about this survey, this study that you did? Why? And what are the main goals of this survey, this study? Thank you.
Pourquoi? Quels ont été les objectifs de cette étude? Merci.
So the working group each year adopts a study where it looks into specific topics of relevance. And since the impunity of perpetrators is really an issue that was on the radar of the working group since the 80s, since the very beginning that it started, it's really an inherent element connected to enforced disappearances. And you would read very much elements on domestic investigations and generally addressing perpetrators in many reports before. Then in 2020, the working group published a report on domestic investigations where it looked into what would be the good patterns, the good tools to investigate precisely enforced disappearances by countries. And when you look at the report, it's striking that most of the good examples come from one particular continent where most of the domestic trials took place, namely from Latin American countries. And a lot of the challenges that we hear now from litigators and from civil society also holds true, of course, in universal jurisdiction cases that concern enforced disappearances. But some of the challenges are unique for universal jurisdiction. They would not appear in the same front for regular domestic cases. And because of that, we decided back in 2023, and actually we took that decision based on the developments happening, based on some judgments that were passed that were not that successful, that we thought could go further. We decided to adopt a study precisely just on universal jurisdiction and enforced disappearances. Last year, after the judgment that we will hear later about as well, we traveled to St. Gallen, to the place where the judgment was issued, to also talk to the prosecution, to learn about what's happening, and also to think what are the challenges, how could those challenges be addressed. So now there's a call for inputs for those of you interested. It's still open until February the 3rd. But if you would be able to contribute and are not able within that deadline, do reach out to me here on the conference or via email. The important part for us is to get good contribution to learn what could be made better. So this study on enforced disappearances and universal jurisdiction is supposed to contain good practices. It will also certainly contain bad practices. It will also contain tools and measures that are found to be useful. So if you know of just one single element that was useful, not even a successful try, just one element, do let us know about that. We know the end game of all of the proceedings. We don't know all the steps in between. So that's also what we want to learn to get in there. And the recommendations that we're making in the study are obviously to the states, but we're also open to make recommendations to other actors. So if you think that in your litigating efforts, or as civil society, as Philip pointed out, they're really the core in bringing cases to universal, in bringing universal jurisdiction cases, if there are some challenges or some good practices with regard to civil society worth pointing out, then that's also something that we would like to hear, and then we can include in our report and in our recommendations.
Thank you so much.
Merci beaucoup.
And well, the time is flying, so I'm now going to speak to Philippe. Could you give me details on the Arensky situation and how can we learn from it?
I have to apologize for those who were part of the precedent panel on fighting impunity. The case was already addressed, so I'll be quite short. But as is the only case that has been brought to court, I think it's important to remind of a few facts. Yuri Harowski was a former member of a Belarusian special unit known for its repressive activities in the 1990s. He was in particular active at the end of the 1990s and participated in the enforced disappearance of 3 very high-profile opposition leaders in Belarus. He defected from the Lukashenko regime and at some point eventually found his way through Germany to Switzerland. And he, for whatever reason, maybe to support his asylum claim, went public about his participation in that unit's crimes, and especially those 3 enforced disappearances. So he publicly admitted on a number of occasions on radio and even in television on Deutsche Welle, his role in said disappearances. Based on that, Trial International, so my organization and our partners, FIDH and Jasna, upon learning of his presence in Switzerland, investigated to find where exactly he was living, and then filed a criminal complaint in support of 2 of the relatives of the disappeared. This prompted, of course, an investigation in St. Gallen. So St. Gallen is a small canton in the eastern side of Switzerland. They never had any enforced disappearance case. It was the first case actually in Switzerland and anywhere on universal jurisdiction. So this was brand new, based on a new article in the criminal code that had been adopted after Switzerland ratified the convention. The case was able to move ahead. I'm not going to go into the details of the investigation, but the trial was pretty brief. Took place in September 2023. Unfortunately, the suspect or the accused was acquitted. The judges had a bit of difficulty believing everything he had said. He contradicted himself here or there. But what was very peculiar is that you had the prosecution, the defense, and the civil parties all saying the same thing, that he had participated in those events, but the court was not convinced exactly. So for that reason, on a factual basis, thought that the evidence was not proven beyond reasonable doubt, and they thus acquitted him. So at this stage, at least, a negative outcome. But I think we have to weigh that and put it into perspective. There are some positive outcomes from the trial. First of all, it's the first trial that took place. It's a meager consolation, but still, it shows that countries can and should, of course, investigate these cases and bring them to justice. It kind of opens the door, sets a precedent that other states can now reproduce. I think for the victims, it was also very important to have their day in court, to be heard by the prosecutors. They were not, unfortunately, heard by the court. They were not able to illustrate the human impact of enforced disappearances on them. So that was a bit of a shortcoming. But the fact that the trial took place was also, in terms of awareness raising, very important. Awareness raising of this particular crime. There was a huge amount of media attention, but also the fact that those crimes took place in Belarus. The first time we had a case on Belarus, and the court was, even if they acquitted the accused, was keen on saying the Lukashenko regime is responsible for those disappearances. So again, a meager consolation. There were problems of translation, interpretation, in particular the plaintiffs. One of them did not speak German, and to be honest, probably had no idea what was going on in the court, had to rely on her neighbor to translate what was being said. So that was not really a good way of operating, of making the victims participate in the court proceedings. We also felt, for those who were present there, that the case was handled as a normal case of drug possession or domestic violence or whatever. The court fell, I think, pretty short of the standards that such cases should bring with them, especially considering the historic nature of the trial. The court was composed of 3 judges, 1 professional and 2 lay judges. One of them a pharmacologist, the other one a police officer. So that's the type of people that have to decide on the first case anywhere in the world how you apply universal jurisdiction. It wasn't really the best configuration for a trial. They were not ready for the media attention. They were not ready to handle those complicated legal issues, and in the end, kind of sidelined the whole thing with the question of evidence and lack of credibility. The case is still ongoing. An appeal has been filed, so it's not the end of the story. We'll see what comes out of it.
Thank you so much. Thank you, Philippe. This shows the wide diversity of the different countries, the different way countries have of operating. Before we finish with you, there is anything, Philippe, you would like to add? What would be, for you, the greatest difficulty you have faced regarding the application of universal jurisdiction in Switzerland, but not just Switzerland?
It's on. So universal jurisdiction is not a panacea. It's one way to fill the huge impunity gap that exists. We should all strive for justice to happen where the crimes took place, so that the affected communities can really possess the process. When it happens elsewhere, it makes things a bit more complicated for everybody, including prosecutors, who sometimes have to access evidence that is on the other side of the world. It brings along risks for victims. There can be threats to their relatives, to themselves. It requires a lot of courage from them. It could be risky for lawyers taking part in these processes. I think one of the important things is that at the individual level for victims, it can, in some circumstances, when the stars align, bring a sense of justice, right to truth, understand what happened, right to justice, eventually seeing the perpetrator sentenced, maybe the right to reparations. Some courts can also accord reparations. But also when you have many of these cases, it puts a lot of pressure on the state where the crimes were committed to itself show that it can do something. We've seen that in cases around Gambia or Liberia, where a lot of those cases in Germany, in France, in Switzerland, in the US have happened. It puts pressure on the government at home to kind of say, okay, we need ourselves now to be seen as doing something. And both of those countries have set up special war crimes tribunals or a hybrid tribunal for the Gambia to now start adjudicating on atrocity crimes.
Merci beaucoup. Je vais appeler à présent
Okay.
nos deux
So
intervenants
now we will
suivants,
have some more
Andreas
participants.
Scholler et Luciano HAZAN,
We can have them on
s'ils veulent
stage
bien
now so that
venir,
we can continue.
à la tribune. Donc, Luciano ou
Okay,
Luciano?
so
Luciano HAZAN
Luciano
est avocat.
HAZAN is a
Il a consacré sa
lawyer,
carrière
former
à la défense des
member
droits humains.
of
C'est
the
un ancien
UN work
membre
group
du groupe de
on
travail des
enforced
Nations Unies
disappearances
sur les disparitions
and the
forcées
Committee on
et
Enforced
du comité des
Disappearances.
disparitions
He's
forcées.
also
Et il est également un
head
acteur
of
tout à
the
fait
program
majeur et clé
against
dans le programme
institutional
de lutte
violence in
contre la
Argentina.
violence institutionnelle en Argentine.
And he's also been
Et
the
Luciano, vous
lawyer
avez également
of
été
the
l'avocat
Abuelas de
du
la
grand
Plaza de
maire de
Mayo,
la place
which
de Mayo,
is a
qui
unique
est
experience
une
and
expérience tout à
particularly
fait
interesting one.
remarquable et
I
particulièrement
would like to
intéressante.
know what
Alors moi,
are
j'aimerais
today
savoir quelles sont
the
aujourd'hui
lessons that you can draw
les leçons que
from
vous tireriez
these
des affaires
universal
de
jurisdiction
compétences universelles
contexts
en
in
Argentine.
Argentina. What would
Qu'est-ce que
you
vous
like to share
aimeriez
with
là
us today?
aujourd'hui partager avec nous?
Thank you so much. I am going to speak in Spanish, so those of you that need interpretation, you have the time. I can speak in English, but not that good.
It's nice.
I cannot speak
Well,
in French.
for
for
starters,
sure.
well, thank you very much to the organizers of the
Bueno,
Congress,
antes que nada,
those who've
muchísimas
been
gracias a quienes han
behind the
organizado este
scenes. It's
congreso,
important to stress that it's a
quienes han
unique
estado detrás. Me
moment.
parece que es
We need
importante
to make the
destacarlo.
most of it,
Me parece que
and
es un
it shouldn't
momento
end
único
tomorrow. This
que
should be
debemos
the
aprovechar y que
starting
no
point
debe
of a very
terminarse
important process. I
mañana,
believe
sino
this
que
is
tiene que ser el
a
inicio de un
snapshot
proceso importante. Quería aprovechar
that is truly
para decir eso.
generating a
Me parece que es una
milestone
foto
in the fight
que
against enforced disappearances.
realmente genera
I'm
un hito
going to get down
en la
to
lucha contra las
business
desapariciones
and go to
forzadas.
your question
Voy
on
de lleno
universal jurisdiction in
a la
Argentina.
pregunta, ¿no?
Very short
Sobre
introduction. There was a
la jurisdicción
military
universal en
dictatorship in
Argentina.
Argentina,
Muy breve
civil
introducción para que
military
se entienda. En Argentina hubo una
regime
dictadura
between
militar entre
1976 and
1900 cívico-militar, porque hubo
1886,
participación civil
83,
también,
apologies, and that
entre
dictatorship
1976 y
was a very
1983.
bloody
Esa
dictatorship, basically,
dictadura fue
but
una dictadura muy
one
sangrienta,
century
pero
before there
tuvo
was a very
básicamente
serious
un
one, a
siglo de
bloody one
dictaduras
as well,
antes también.
and
No fue la
this
primera
used
dictadura que hubo en
enforced
Argentina,
disappearances
fue la última y la más
systematically
sangrienta. Esa dictadura utilizó la desaparición forzada
in the framework of a
de manera
repressive
sistemática
situation against political
en el
dissidents.
marco de un plan
Many of you,
represivo
for
contra
sure,
toda forma de
have
disidencia
all the
política.
details. We don't have a lot of time, so
Seguramente muchos de ustedes
that's
ya
where I'll
tienen el
stop.
resto de los detalles.
When
Tenemos
Argentina
bastante
goes back
poco
to
tiempo.
democracy in
Me detengo ahí.
1983,
Cuando Argentina recupera la
it
democracia en
starts a
1983,
truth and memory process
inicia un proceso de memoria y verdad, si
focused
se quiere,
mainly on a committee on truth with the Nunca Más reports. I'm
focalizado
sure
sobre todo en
you've
una
heard about
comisión de la
the
verdad que
reports.
elaboró el informe Nunca Más, que seguramente habrán escuchado hablar
And
de
the
ese
next
informe
step
y
was the juicio de
como
las juntas,
paso
bringing to
siguiente se
court the
llevó
maximum
adelante el denominado
authorities
juicio a las
of the
juntas, el
military
juicio
regime.
a las
Perhaps
máximas
you've seen a
autoridades del poder
film that
militar
was well known
durante la
last year or
dictadura
2 years
argentina.
ago,
Tal vez han visto una
and I recommend
película
you
que
watch
tuvo
it
bastante repercusión el año
on the
pasado o hace 2
platforms,
años,
which tells the
que
story
si no
of
se las
this very
recomiendo, está
important
en
trial,
las plataformas, que cuenta la
which
historia
was
de ese
a truly
juicio muy
unique
importante,
trial
que
in the
fue un
world
juicio
with this criminal procedure, a local one without the need of creating any type of structure or alternative procedure or special procedure. This allocated a very relevant value to it. After this juicio a las juntas, or juntas trial, the families of the victims started to, criminally prosecute other perpetrators and not just those at the top level of the decision-making process. This generated a strong pressure on the military sphere with attempted coup d'etat and also the establishment in Argentina that had been involved in the dictatorship as well, because the dictatorship, of course, had interests of different kinds, not just political, but also economic and changing the society. This pressure led on to two amnesty laws and indultation of all military professionals that had been sentenced. And as we've heard today, when we speak about universal jurisdiction, we speak about this because enforced disappearance is an international crime that is somehow defined by impunity. The impunity is a part of this as a state crime. And what happens in Argentina, especially with the relatives of missing people and the NGOs that had been accompanying them, they started to think about different strategies to fight impunity. The use of universal jurisdiction, therefore, in Argentina could be an additional element within a wide array of strategies. And we could mention litigations in the human rights courts, because it established different truth trials. These trials had no punitive sentences, but they were trials in courts that at least gave victims and witnesses reparation, but it had a huge impact in terms of enabling victims to be in court and go to court. So it was progress. There was reparation laws as well, and the search for missing children, the task done by Abuelas de Plaza de Mayo, had not been limited by the amnesty laws. So those cases moved forward as well with a very strong impact on the public agenda. The sons and the daughters that had disappeared were now teenagers in this impunity area. So they started to become organized and they started with scratches. What were scratches? So-called scratches in Argentina. They were public demonstrations that the sons and daughters of disappeared people started in the houses or in the doors of the perpetrators. So they were telling all the neighbors, pointing the homes where these people lived. This person that is giving you salt and sugar are genocidal people. They made 30,000 people disappear. They participated in the disappearance of 20,000 people. They killed people and committed crimes against humanity. So anyway, I could explain the entire process for longer, but the goal of universal jurisdiction is basically enmarked or framed in this wider strategy. The goal family members had was a multiple one for the use of this universal jurisdiction. On the one hand, the documentation of facts, of course, universal jurisdiction was used when there was no use of testimonies. And even if it were in foreign courts, families could go there and tell and talk about what had happened. Also, this same restorative effect. It's not just the same to have your witness written in a report than being in a justice court in the face of judges. Of course, the solemnity framework in Argentina, we learned that it had a very relevant restorative effect. And apart from this justice effect that could mean a possible sentencing in a third country, was that of generating the necessary political pressure and also legal pressure so that cases could be reopened in Argentina, so as to break the impunity framework created by these amnesty laws and what had happened so far with pardons. These cases of universal jurisdiction took place, many of you will know, those of the former Judge Garzón in Spain in the National Audience or courts, and basically many different top-level professionals were imputed and held accountable with Juez Garzón, Judge Garzón, and Cilingo was condemned for 30 victims. And the interesting thing there is that there was no necessary link between the victims and Spain. Here we're talking about a universal jurisdiction case that is a strict universal jurisdiction case. In Germany, there was the case for the disappearance of Elizabeth Kassermann, a German woman who disappeared in Argentina. Germany requested the detention of Emilio Massera, and one of the main leaders in France. There was also the process for the disappearance of Alice de Mons and Leonie Duquet, the nuns taken to the School of the Army, the main concentration camp of the Marine Department, and that was Alfredo Astiz was condemned in absence, a military in intelligence that has had huge repercussion, and he had been in the group of families and relatives. He was condemned in absence. Well, we could speak about absence trials later if you want. It was useful here. When we speak about universal jurisdiction, this absent trial could be a tool, of course. And we should also have a critical perspective. I have a bit of a confusion regarding this absence trial. I don't know whether it's good or bad as a negative aspect. One thing that we can see is that since the accused or defendant is not there, well, there's no truth process or best possible scenario for a court to make a decision or a ruling. In the end of the day, it is just the statement of the prosecutor. And in Italy, there was also investigations of disappearances in Argentina, of disappearances of Italian nationals in Argentina. So when all these cases start to request an extradition of the Argentinian military in the year 2000, President La Rúa brought out a decree denying extradition, saying that no military would be given to be judged except for the possibility of trials in absence. This universal jurisdiction of cases in Argentina was locked, or rather blocked. So somehow the decision of the executive power of non-extradition generated this political space so that there could be a serious debate in the litigation with families, the reopening of trials. The other side of the coin, and I don't have a lot of time to tackle it, is the jurisdiction exercise in Argentina on foreign cases of human rights violations and other cases. I'm going to give you a list, of course, because I no longer have time, but crimes committed in China against Falun Gong, crimes against humanity in Paraguay, cases has been started in Myanmar, and we have some time later we can talk about cases presented in terms of human rights violations and sometimes enforced disappearances in the Gaza Strip, Cuba, Venezuela, Serbia, Saudi Arabia, Turkey, Colombia, Nicaragua, Israel, Yemen. There's been large and big cases there. So what's the situation now? There's no law for the exercise of universal jurisdiction in Argentina. There is a constitutional article that enables jurisdiction when we find ourselves in the face of this right. And there's the Rome Statute that also gives meaning to this. So the High Court and several courts have used these rulings to move these processes and make them progress, but the general prosecutor brought out some rules. The most recent one is a December ruling, establishing that, based on what I understand, is that the prosecutor basically wanted to give a regulation which is also limiting, and this is important in the face of all these cases that generate expectation, of course. Somehow it is legitimating prosecution because it is a regulation, and somehow it is legitimating. We would need to close now. Yes, it is important to say that in that regulation, what the general prosecutor does is give the possibility of using universal jurisdiction against any case that has no link with Argentina. So this clearly is limiting regulation, and perhaps this is food for thought for later, but I believe that the main challenge is to try and democratize universal jurisdiction, try to generate cooperation mechanisms between different countries that are not only the central countries, even countries in the margins such as Argentina or other countries exercising universal jurisdiction, to be able to somehow generate a network that prevents from political pressures to come in. This is what's affecting Argentina nowadays. Thank you very much. Thank you. Thank you. I had to stop you. Sorry for interrupting you, but we have some other people also who need to tell us about different things. I'm now going to speak to Andrea Schuler, also a lawyer in Germany, in Berlin, and director of the International Crimes and Accountability Program for the European Center for Constitutional and Human Rights. You have a very significant experience of universal jurisdiction. And the first question I would like to ask is related to the German law and the progress it's made on international crimes, the crimes that are of interest for us today, the crimes related to enforced disappearances.
Oui, merci beaucoup. I'll respond in English. Yeah, thank you very much for the invitation, and thank you very much also to be here at the World Congress, and also really great to see so many organizations here that include survivors. It's based on victims' demands and having them participating here. So it's encouraging to see full halls here and the conference hall with so many people on this topic. I think that's really encouraging. And I think it's quite important as a World Congress to bring all those groups and people together here. Very briefly, to follow up on what Luciano just said on Argentina, I think it's an excellent example to use universal jurisdiction worldwide to also then push for local trials again in Argentina that then happened all these years. And interestingly, then 4 or 5 years ago, there was the trials in Argentina, the prosecutions also in Chile actually led perpetrators then flee, for example, to Germany because they had a German passport, and Germany could not extradite them because Germany does not extradite those with a German passport. So it meant that Germany needs to do those cases and prosecute them, and completely failed to do so far on Chile, because the prosecutor was not willing to prosecute those cases because there was no enforced disappearance law in place in Germany until August last year. Actually, it was just introduced 4 months ago as a standalone crime under German criminal law. And in an Argentinian case, there was a 250 pages indictment by the Berlin prosecutor, finalized and approved by the court, and then the suspect passed away. We published that indictment as a historic record and translated it also into Spanish, so at least this is there. It was quite interesting to have the old cases in Germany. You mentioned 2002, 2003, and then a new one in 2023, which again didn't lead to any prosecution. But it's the interesting part how these cases are going back and forth, and I think that's super relevant. We at ECCHR started already in 2013 trying to amend the German law with a standalone crime of enforced disappearances. We only succeeded 6 months ago after a 10-year battle, also complaining to the Committee on Enforced Disappearances during the state reporting, got some strong recommendations all these years. But actually, it was also a case on Syria that brought some changes, because in 2019 there was a first big trial going on in Germany based on universal jurisdiction again against 2 members of the Syrian regime. They were prosecuted in the court of Koblenz, called the Al-Khatib trial, on charges of torture and killings, and later also on sexual violence, but not on enforced disappearances, although it was a detention branch in Damascus, where many people disappeared. Through our partner lawyers, we tried to amend the charges with filing a motion to request that crimes against humanity charges or enforced disappearance as a crime against humanity are added to the indictment. It was rejected by the prosecutor and by the court. And the critical part was that the German definition is based on the Rome Statute from 1998, with a plus, which said that it was needed that an official refused to tell about the whereabouts about the disappeared people up on inquiry instead. And this up on inquiry was interpreted by the prosecutor and the judge that the relatives of a disappeared person would need to formally ask the authorities who likely disappeared the person about the whereabouts, and you need to prove that in court, which, if you know the situation in Syria back then, was impossible to do, and I think it also became clear to everyone. So we also raised that after the end of the trial, that we need a legal change here on the definition, plus this standalone crime of enforced disappearances. And with then the war and the aggression against Ukraine, there was some willingness to change and reform the German law. So this up on inquiry definition is now deleted. So we hope that makes it easier for prosecutors to include enforced disappearance charges in future cases. And we got a standalone crime, which then also allows for other cases that are not crimes against humanity to also being prosecuted in German courts for the future. So that's, in a very nutshell, the past 10 years of legal reform, litigation, and how this all influences each other. And you see also the problematic with having the Rome Statute definition as the leading one. Then the convention comes only later, but even in the reform now, they only went back to delete these 2 words from the Rome Statute definition, but not more, which we think would have been appropriate concerning given that you have a different definition in the convention, of course. So I think that describes a bit the situation.
Merci beaucoup. Est-ce que, en 2 mots, vraiment en 2 mots,
Thank you so much. So what would be the practical recommendation, because you do have a very vast experience of the application of universal jurisdiction. So what would your recommendation?
Yeah, sure. I mean, I think it's important first that prosecutors, police are aware that enforced disappearances exist in the law, that in investigations, questions are asked into that direction, and not only in the direction of torture that happened, of arbitrary detention that happened, but also to establish all the elements you need for enforced disappearances. So I think it's the awareness and also maybe training for prosecutors and police here. I think it's quite important. And I think moreover, we have also the difficulties that usually you mentioned the link to Argentina that's now needed, that you have universal jurisdiction cases usually only being triggered if there's a link, or even more so if there's a suspect present in the territory or even residing on the territory. And then you start a case, whereas we think universal jurisdiction also permits all states basically to gather evidence and to then share evidence with colleagues in other jurisdictions to build cases. And this connection of evidence part is hardly done. In some few situations it's happening, but in very few. And in all others, it's based on opportunity where a perpetrator is in the country, whether you do a case or not. And then you have even difficulties to build the case and gather the evidence, as also Philippe mentioned before. So I think there needs to be more knowledge, but also more resources and more willingness to secure evidence for future cases, and not only wait until you identify a perpetrator on your territory or NGOs point you to someone being present. So I think these are some of the main obstacles we still have on good intentions, also with the conventions and the obligations in there, and then practically how it's very restrictive only applied.
Merci beaucoup, et je remercie donc nos deux intervenants, et je vais appeler les 3 prochains intervenants. Merci.
Clémence Bectar, Obeda Daba, and Mazen Darwish.
Clémence
Please.
Bectar, Obeda Dabag et Mazen Darwish.
It is a pleasure to have amongst us Clémence Bectar, a lawyer in Paris, and she's committed and also a coordinator of judiciary action of the FDH. And Clémence is following for many years the victims in various special cases such as Daba, the case. How is it pronounced? Dabak? Dabai? Dabai. Dabai. I didn't know it, how to pronounce it. Together with Clémence, we have amongst us, and we had the pleasure to work together for the implementation of the Institute of the International Penal Court for the domestic legislation in France, for universal law in France. But this is another discussion. Clémence, I'd like you to talk about the Dabai and Enema issues and also the challenges related with these cases. Thank you very much and welcome everyone. Thank you. It is a pleasure to be today with you and to be a member of the First World Congress. I'm going to talk about the situation in France after the different cases of forced disappearation, whether it's an autonomous case or also that constitutes a crime against human rights. The situation is similar to the previous one. So this panel will deal with this perspective, and we will see what are the very few cases that we have in the courts where the forced disappearation cases are treated. We don't have too many processes, as we said, and this situation is similar in France. In France, we do have an autonomous case that stems from the Convention Against Forced Disparitions from 2013. It's less recent than the German one that Andreas mentioned before. We could think that there are more cases today. However, this is not the case in France. There are only 2 cases where the case was abandoned, and the second one that started the first process in France for the crimes as a case against human rights that was judged in May. I do represent Obeida Dabai together with the disappeared people in Syria, and also the organization Mazendawich, the Syrian Center for Media and Freedom of Speech. So, crime as an infraction in 2013, a translation of the Rome Statute after a law in 2010, and several years later, very few processes. Just one process related with forced disparition. I think that the legal authorities in France will have to answer why, but there are some hints that will share why there are so few legal processes related with forced disparition cases. Of course, this has to do with the previous speakers. There was a recommendation made by Andreas Schuler. There is a very weak knowledge. There is a lack of knowledge of these crimes and all the legal specificities that the crimes have. Also, the facts that these crimes have. This is translated in front of some situations where the prosecutor in France has no tools, whether they need to have an holistic perspective, a 360 perspective, to better know what are the qualifications and the features against an individual that, well, was the cause of these forced disparitions. It is something very difficult. Also, the situation should have to get a new perspective, or maybe something that does not exist in France, to keep this infraction, this legal problem, something that goes against human rights. But this is not today's case. And I do totally agree with the previous words. It is important to create new sensitivity, to train the legal professionals to be aware about this crime, and also to add other features once we are aware about well-known crimes such as the Syrian case. And also, once we are aware about these 2 cases in Syria, 2 cases that brought to France the ability to follow up the individuals, the criminals, and the ones that suffered the disparition, and autonomous, so the NEMA case, I'm going to talk about it very briefly, and also the Dabag case that opened the door to this first process in France. As for the NEMA case, the NEMA process, we talked about a claim that under the CM, the Center for Mazem Darwish and the FDH, victims against a group of an armed group, the Aish al-Islam. Well, they claim against them in the region of the Eastern Conda, and there were forced disparition crimes that were committed in a very flagrant way against one of the icons, such as Rezan Zaitouni, one of the icons of the Syrian revolution, and 3 other colleagues that were victims of forced disparition. That's why we presented this claim in front of the court in France as a forced disparition, together with other cases and qualifications. Well, a suspicious member was arrested, and he was able to defend himself. There was a legal question that was placed, and the judges, after the Court of Appeal, and after that the Cassation Court. The idea is to know if the responsible can pay for these crimes of forced desperation. The same argument was supported by the plaintiff under the Convention of the UN against torture, and the solution that we found is not the same as the one that we have for torture crimes, and the legal jurisdiction made evolve the international law and admitted that the crime from the disposition could be imposed to a non-French actor, but there were not enough elements to force the responsible that belong to an armed group to be guilty. So we are right now in a situation where the process that is going to be held this year, and these forced disparitions were rejected, therefore they won't be included in the qualification for this member to be judged in May and June. As for Dabak, and Fiobeda is going to talk about it. As for the Dabak case, because he knows much more than I do. He's very close, and he's a relative of these disappeared people. It's his brother and brother-in-law. The 3 and 4th November 2013 in Syria, they disappeared. But in any case, well, from a legal perspective, this has been the first process that included the forced desperation crime against human rights in France. It was essential to us, mainly due to two reasons. As we implement the legal legislation, there was no open process related with Syria and related with the forced desperation. So we know to what extent this issue was vital and how disparitions was used against the Syrian population, 350,000 disappeared people. It is vital, this crime, to make part of these crimes all along the service and all along the processes in France. And also, equally is important, because in Baydalab will talk much better than I'll do, beyond this specific case that has to do with the French, also the case of Patrick and Messem Adaba, a father and a son that disappeared in Syria. Also, it has to be the flagship of this, the forced disappeared people in Syria. Once again, we need to take into account these forced disparitions in Syria and to condemn all kinds of crimes that stem from these forced disparition cases in Syria. Also the extortion, the blackmailing, and all these problems that suffered the relatives, not only the Bagak family, but also all the relatives that are victims of forced disparition in Syria. So we are fighting for the truth. Also, how goods were stolen. Sometimes, well, they had to suffer many tricky situations. So this phenomenon to us is very important to us. We do need a legal translation of the facts and also to share this crime through the Abak case. Thank you very much, Clemence. Maybe I'd like to address you, and you are Mr. Obeda Damak, and you are the aunt and the brother of Patrick Labak that disappeared in Syria. Thank you very much for being with us today. And thank you for your presence and for your testimonial. I'd like you to share with us, as members and relatives of the family of the victims, what was the most complicated things? What are the challenges that you had to face all along the procedure, this legal procedure, and something else that is also very interesting to us? What have been the elements that gave you support? What was fundamental to you? What was the most important support that you got in this fight? Well, you know, everything started in 2013. Patrick, my nephew, and the day after my brother. A week after, I did get in my phone a message from IFA, my sister-in-law, that told me that my son and Patrick were kidnapped by the army. Can you do something? Well, I said, this is almost impossible. What can I do? What can I do myself? Well, I thought a little bit. And after that, suddenly it came to my mind, well, my brother, he is French. Maybe I could inform the French authorities about the situation. I started. I was a former member in the French school in Damascus. So I get in touch with the principal of the school, and he told me, well, this is kind of a tricky and a complicated issue, how to face security in Syria. Right now, it's not an easy thing to do. And I said to myself, okay, no problem. I tried another source, and finally, the Ministry of Foreign Affairs in France, and there was a crisis center. I phoned them, and someone answered me, and I tell this person that my brother had been kidnapped by the Syrian authorities. What can we do? And they answered me, well, Syria and the rule of law in Syria is very complicated. We cannot do anything. Well, you cannot do anything? And he told me, well, I'll try to get in touch with the ambassador, the French ambassador in Lebanon. We'll try to see what can we do. Okay. So nothing happened, and tens and tens of calls, and I felt that they really needed the information. It was not me who needed more information. Suddenly I realized, what can we do? I said to myself, maybe we can go higher. Maybe we can write an email to Mr. Hollande, the former Prime Minister, and also to Mr. Fabius, the Ministry of Foreign Affairs in France. So I reached higher and higher. And well, I did get an email very rapidly, an answer. And well, they told me that they will trying to do the best as they could, and that they will assign the Ministry of Foreign Affairs to manage the issue. And I said, okay, things were evolving and progressing. Several weeks after, I did get an email from the Secretary of Mr. Fabius, the Prime Minister of France, and are you a brother of Mr. Mefem? Are you sure that her mother and they do need to do or want to do something? Well, I don't know. We don't have the written consent. I don't know if they will do it. We do need the written consent of your wife. Okay. Anyway, I realized that they had to do something. I called my sister-in-law and I let them know, listen, you have to do this and that. Despite they were afraid, and she was very afraid, but well, she was helpful. And I sent an email, and I sent several emails to different responsibles, and nothing happened. Well, nothing happened. A month went by, and I wrote an email to the teacher trade unions. I sent, oh yes, your brother is a teacher. Let's try to see what happened in Syria. And later, the Red Cross International, yes, we do have a relationship with the Red Crescent in Syria. We'll try to find some information. I wrote a letter to the Red Crescent in Syria to know what happened there, and nothing happened. Okay. 2 years after, 3 years after, they told me we didn't found your brother, neither your nephew. Okay. Meanwhile, I listened to the news, and there were some MPs that went to Syria with all other senators and political responsibles and Mr. XYZ. And well, I went to the Senate, to the National Assembly, to the Congress. I shared the case. They had contacts in Syria. They told me, we'll make our best, no worries, you will have a very quick answer. And nothing happened. Well, what can I do? I told them, well, I was a little bit desperate, and I said to myself, well, my brother is a French citizen. We are the fifth power in the world. Why cannot intervene? Why cannot block the information services in Syria? Well, there were French citizens that, I didn't understand what happened. So suddenly one day, and 2 years went by, it's October 2015, and in the newspaper Le Monde, Mr. Fabius asked to the General Office Against War Crimes, if there were some French national that appeared in the César report that made a list of the 11,000 tortured victims. And, well, my brother was not in that list because he was kidnapped 2 years after the first version of this list. And I said to myself, well, maybe we could ask to phone the commander of the office. Well, you can declare whatever you want. And well, I brought myself my wife. My wife had a cousin, and well, she did a declaration. She was not French by that time. Okay, nothing happened. And finally, this case was the starting point of my legal action, because in reality, the FDH, having conversation together with the office, knew my problem, knew about me. Suddenly, I got a call from Clemence. She was there, and it was paradise to me. It was heaven in earth. I was so motivated. I wanted to make this case to progress. No worries, your brother is French. We could do something here and there. And yes, we did our best. And in 2016, just a question. Before Clement's contact, you didn't think about starting a legal action? No, I never thought about it. I was lost. I didn't know what to do. I was a regular, an ordinary citizen, never had access to justice system, so I didn't imagine about how to do it. I didn't know how to do it and how to proceed. I never thought about legal process as well. You know, and after that, Gabriel came to help us, and he told me, Mr. Dabag, we will help you in this specific case. Okay, I said to myself, all right. Meanwhile, I forgot something. The actions that I made here in France, I made it in parallel in Syria, right? Many people, many relatives, and also military and people that belong to the regime, they tell me, no worries, he will appear. And little by little, well, we made questions. And suddenly I was told that I will have problems. But, well, we paid to the kidnappers, and someone came to France, and we are ready to. So in the end, there was kind of a first. It was by the time, how it was called. The prosecutor, yes, we had a case of forced desperation and torture. Well, I didn't want to talk about it. Forced desperation, I knew about torture because Syria was a totalitarian regime, but forced desperation, well, my brother had disappeared, of course. 12 years ago, the final message that we got. And by that time, we didn't get more information. And I said to myself, okay, this is the information. And the case was presented. And meanwhile, they invade and they make the family home to be emptied, and the wife and the daughter had to leave the family home by force. So I made a claim in Damascus. Of course, I did know that there were no results because legal system in Syria was very difficult to accept. And suddenly, little by little, you know that the ones that stole the house were the chief of the investigation board at the airport of Mazem, together with his son and his brother. So they took the family home, and many other informations that were important for the processes that finally, after that, in 2018, we cannot share everything because I realize that time flies. Anyway, so what was the support that you get? What was essential? Yes, justice. legal system. If you allow me, for my brother-in-law, for my nephew, through the process, I think that all Syrian people that suffered the same case as my brother, so it is a case that includes tens of thousands of Syrian people that disappeared. Fortunately enough, well, we had to see the three military and Jami Hassan, the chief of research investigation, together with others in the prosecutor and the court wanted to start the process. The process was held in May 2024. They condemned these three individuals, this crime as against the humanity, and it was a victory that was unexpected. So the legal part started in 2016 and it finished in 2024, 8 years. And all the processes before, more 5 years. So finally, politicians, they do not anything, despite I talked with Mr. Macron, Lady Macron, Mr. Ribrian, and many others. This for you to tell you that the politicians, they don't care. They don't care anything. It is important to get in touch with the families. Families, they should not be scared about anything. My family was against at the beginning, whether my women, my wife families. So I had to follow up with obstination and stubborn, and I did it. Otherwise, we would have never obtained what we got. I hope that the legal system will face the future cases in the liberated Syria. And you were very obstinate and stubborn. Yes, thank you.
Mais quelle obstination il a fallu.
And now I'd like to talk with you, Mr. Bawi. You are a Syrian lawyer for media and freedom of speech in Syria. You're also Secretary General of the FDH. Former, okay, former FDH. And you have a very long experience with human rights. You were in prison as well. So we are in front of someone very important. We are more than happy to come with you. We are more than happy to listen and also to know about what's your vision and what are your skills and everything that has to do with Syria.
Compétences universelles dans les affaires concernant la Syrie.
Thank you very much. And yeah, it's very important to be here in this day, especially after the fall down of the Syrian regime, and I will be happy. Yeah. That there is maybe minimum more than 150,000 family of missing person in Syria. Now they have hope or chance to know the truth and the fate of their lover. And this is the number, maybe the minimum. So yeah, I think as a Syrian, we will keep celebrate for next 50 years every day. And this number also means that there is almost no family in Syria don't link or have someone related missing. So for us as a Syrian, this is something huge, and this is part from our future. We'll keep fighting for the faith and the truth. Unfortunately, for maybe next 20, 30 years. But in these two cases, especially two cases about Syria, I think there is a lot of hope, fight, without the victim themselves. When I looking to Ad-Dabbagh, Mr. and Mrs. Ad-Dabbagh, both without their fight, without their leadership also in this regard, we will never be able to do anything. These cases also lead to many relative things. Usually we don't mention when we are talking about enforced disappearance, the economic side, because as I know, there is blackmailing all the families from the authorities, and they make this enforced disappearance also as a machine to stolen money from the families to know anything about the faith of their relative. So we are talking about, and this is also, I believe, what happened with the Dabbagh family. They spent thousands of euro to catch any information. And also, this is a tools used from these kind of regimes also to stolen the property. We know also from Mazen and Patrick at Dabbagh how the Syrian authority also stolen legally the property they are building, and the officer who led the investigation branch in the Air Force Security Service, he live in this, stay in this property in this house. So also this is one of the faces of the enforced disappearance in Syria, and I believe also in everywhere. But also we can speak about the necessary of cooperating with the local organization and local human rights defender, because I believe that, yes, as all the panelists speak and say, that there is a lot of a problem. We can go to the crime scene and collect evidence directly from the crime scene. For this is very important, this kind of cooperation. And in this case specifically also, the victim themselves, they also try their best to bring evidence. And sometimes it's the evidence not only in the crime scene itself, but we have evidence, I think, from the civil registry. And we have also evidence also from the financial ministry in this regard, even from the open source, from the official TV in this regard. So also, yes, it's difficult. We can go and investigate and collect evidence from the crime scene, but also this does not mean that there is no any possibility to bring evidence in this regard. Also, these two cases raise a very essential issue about access to justice. And even in Germany, in Al Khatib trial, we faces this problem that there is a huge number, or maybe sometimes the most important witness and key witness in these cases, we can't bring them to justice because they are not in Europe, or there is no possibility to bring them regarding the visa issue. So access to justice. And in this issue, I think we need to be very careful, because sometimes we send messages to the victim, even if we don't mean it, but the victim receives the message like this: if you have European nationality, so you deserve justice. If you don't have, so you don't deserve justice. If you have visa or access, or you are in Europe, so you can go to the court and give your testimony. If you can't, if you are in Syria and Lebanon and Turkey and any other places, so you can't, and your testimony, it's not necessary or not important. And this is something we need to put it in our consideration. I need also to raise something. It's not also for sure. I can say that I have the same feeling about Mazen and Patrick, like his brother or his wife or daughter. But also, this is about our narrative. It's not about only the verdict or who's responsible. This is about the narrative, about what happened. I was there in the same prison, in the same detention center. I was also first disappeared in this place. So I feel that this is also my story. Now I can say it regarding the evidence, the verdict, regarding the story of Mazen and Patrick. I can say, yeah, this is what happened to us. No need to believe me or not. Now you have this court decision, you have this story, and this is also for us very important. Saving the narrative, what happened. this is also okay. Last thing, I can keep talking a lot, but I know that time.
Je sais, I know.
Last point, I think it's very important. We need to take care about the psychology support for the family, for the victim, for the witness, for those who's working in this field. And now, after the regime fell down and collapsed, I think I need to go to a mental hospital for 1 year just to just for nothing, for retreat. So it's very important, especially for the victim. And this is usually, or sometimes the victim doesn't say it or ask for it, but believe me, it's very important, very essential.
Merci, thank you very much. Alors,
Ahora tienes
Clémence,
30 segundos
tu as 30 secondes
para
pour rajouter un
añadir
point.
cosas. Sí, dos cosas sobre este, on this process. Patrick Mazgan was French and Syrian, and they do have the right to activate a repair request to French authorities. This is the first time that there will be such case. It's the first time we are going to use this concept of enforced disappearance, so that it is also included in the legal history of France. And it is important for us because the next thing is that in the perspective of the fall of the Syrian regime, it will be important to see how these trials and how other investigations can contribute to this transitional legal process in Syria with this enforced disappearances, and how investigations can contribute to the processes that will take place in Syria in the future in terms of justice for victims. Thank you so much. Thank you for having used your time wisely. Just 3 questions. I would like to ask questions that are not statements, that are truly questions, so that we have time enough to deal with them and answer with the participants and the members of the panel. 3 questions, please.
Je te laisse gérer. Tu fais ton choix.
Hello. Thank you very much for giving me this opportunity. I would like to bring your attention towards the enforced disappearances in occupied Balochistan. Actually, my question is from Flip, but anyone can answer this. Pakistan being responsible for widespread enforced disappearances in Balochistan, and its refusal to sign the International Convention for the protection of all persons from enforced disappearances. How can universal jurisdiction be exercised to hold Pakistani officials accountable? And are there successful precedents of using international tools in cases where a state itself perpetrates such crimes and avoids international treaties? Thank you very much.
Merci.
Okay, so let's go for a second question.
Et ensuite, je laisse mes intervenants
That was
réfléchir
for
à qui va prendre
Philippe.
la question. Philippe, ouais.
Bonjour.
Hello. With what happens in Syria, Lebanon, and other places, do you not believe that we should start working on local jurisdictions and justice? For instance, posing a claim. We know that in France sometimes it's complicated and long, but with what's happening nowadays, shouldn't we place all our efforts in the countries and start thinking about complaints or reporting these things, because there are the families of the disappeared and missing people. They are very important, and also society needs to be able to work on this. And also it would be important to, well, we hear a lot about, no, we need to be in front of justice, but I think it is important for Lebanon and Syria, this in the framework of the current situation, so that we can work again with justice. Thank you very much. We're now going to hear from the panelists. Another question? No, but I'm looking at the time, and I believe it will be complicated to have another question. Okay? So let's answer these two first questions and see whether we have any more time. Philippe, I don't know whether you would like to answer or respond the first question. There are two questions. One is on Pakistan and the other one. Okay, the first question, Philippe, you can answer the first question.
Philippe, je vous laisse peut-être répondre.
If I understood correctly, the question is, can you still use universal jurisdiction to prosecute Pakistani officials, although Pakistan has not ratified the convention? Okay. I think it depends a little bit on the countries where the proceedings might unfold. Well, first of all, as tried to explain, you generally at some point need the presence of a suspect on the territory of the country that will exercise universal jurisdiction. So there's a big work of trying to monitor the travels of potential suspects. You have to do like case building in advance and be prepared, especially when the suspects just travel through a country. That is very difficult to open up criminal investigations when you don't have at least some sort of lasting presence. I'm not saying that you need to be a resident, but just passing through is very complicated. There are just a handful of universal jurisdiction cases that have gone to court when the suspect was arrested when he entered the country. Generally, you need to have a longer presence to allow the authorities to investigate. The fact that Pakistan has not ratified the convention, at least in some countries, would not be an obstacle. Most countries require that the crimes they will be prosecuting are also crimes in the country where they were committed. I assume that it is illegal under Pakistani law to arrest and make people disappear, whatever the legal definition really is. So it's just having the crimes matched in Pakistan and in the country that would prosecute the perpetrators. But I think that the biggest question is, how do you find them? How do you monitor them? That's a big work that has to be undertaken.
Merci beaucoup, Philippe. Je laisse la parole à Clémence, peut-être pour répondre à la deuxième question.
Yes, I can say on behalf of all the victims with whom we work and the relatives of the families, local and national justice is always very complex, and universal jurisdiction is always a system of last resort to create a strategy against impunity. But the final destination of these proceedings, this search, aims at having an effect in the territory, to be close to the victims. And what is important, since the fall of the Syrian regime, is to have this extraterritorial justice to be as close as possible as to the territory. I totally believe that we need to create a local justice, which is the local that needs the one that we need for the future.
Yeah, for sure, totally understand that, and we always say that transitional, the UG or even extraterritorial jurisdiction, it's not our first, but even this is why the universal jurisdiction exists, because we can't have or reach justice or accountability in the local level. So this is also one of the reasons why it's important. And in general, I believe that maybe now, today, we can say it that in Syria and also for the Lebanese disappeared in Lebanon and Syria. Now, all of us, we have hope. We need to work in the local and domestic level to both sides to clarify the fate of the missing and for the accountability also. And we need also to guarantee that this will never happen again, because also when we are talking about not only the security and dictatorship, but also the legal system, it's part from why we reach this level. So there is a lot of work. I believe that it's as a tools, because we can't hold accountability or domestic level. It's very important tools, and we need to use it every time we can. And even if there is no, sometimes feeling there is no direct result, but also it's a message, and very important also message in this regard. Thank you.
Deux questions brèves.
Please. Yes.
Ouais.
See.
Panelists, I happen to participate in research and drafting the report on the disappearances in Belarus of Mr. Pogridis back in 2003. And we had plenty of evidence against the leader of the death squad, Mr. Pavlichenko, and some others that we named in the report. And at the time, the report made quite a big scandal, big impact also in Belarus, but nothing happened. We were then already calling on use of universal jurisdiction, but in 2003, some of the countries that could now act could not. My question is there any way, well, I guess now the passage of time has made it almost impossible to act on the evidence that we collected at the time. And is there any way and the problem of passage of time is always the problem for clarifying, for elucidating enforced disappearances cases in general. How to speed up investigations, how to reduce the lapse of time, which often makes it impossible to find the truth and to hold to account the criminals.
Merci.
Okay, so the last question now. Can you please be short in your questions?
Sorry. Oh, yeah, it's on. Yeah, my question will be kind of linked. Would probably be specifically for Maître Bechtart. Comment est-ce que vous voyez l'évolution du cadre juridique?
How do you see the evolution of universal jurisdiction in France, particularly in that country, in France? Thank you very much for your question. And let's see who wants to answer the first question on how to speed up the processes in terms of universal jurisdiction.
Speeding up, obviously, in this particular case, the enforced disappearances was not codified. So this was really kind of the moment to do it. But I think the question started off with regard to evidence. And here, I think I would like to broaden that up a bit, because with regard to enforced disappearances, it's not only about the evidence that it has occurred, but it's about an evidence that it was actually an enforced disappearance. And that was one of the things that was at stake here and is at stake in many other cases. So that's why in many proceedings, this would rather go as a murder than as an enforced disappearance, because it's so much more difficult from outside to prove that there was an intent, that there was this disappearance element in it. And here, I guess that was also one of the part. And speeding up, of course, is the big question. What can we do about it? And I think that this strategic connecting of investigation, making it more the trainings that Philip talked about, is all something that would go in that direction. But in the end, it comes back to what you said, that it's a domestic that should be doing it, and nothing outside of the domestic. It would always.
Thank you so much, Luciano. Very, very short, please. Yes, thank you.
Luciano, vraiment brièvement, c'est vraiment 2 minutes. Ouais. Ouais, merci.
Just for trying to answer the question about speeding up, I think in my experience, especially in Argentinian cases, the role of civil society supporting victims is the key, because in Argentinian cases, the investigation was done by civil society, by the family associations. They were documenting the cases, putting all that together and bringing it to the judiciary. So in terms of evidence, I could say that most of the job was not done by the judges in these different countries, but by the victims itself. So, of course, that will not solve every problem on time, but it for sure it will help. Of course, that you would need support for those NGOs, financial support. Of course, it's very important. That could be a call for states and big NGOs. Thank you.
Thank you very much.
Do you want to answer the last two questions? Yes, regarding universal jurisdiction. In France, we have a terrible law on universal jurisdiction. It's been amended and slight improvements, but they are not satisfactory for us as civil society. And this entails exclusively considerations in France, where there is still the condition shared by the executive,
partagé par l'exécutif, quels que soient d'ailleurs les présidents, les ministères des Affaires étrangères
and
ou de la
there's the
justice qui se
condition that the
succèdent,
international
conviction que la justice internationale peut dans certains cas être antinomique avec la
department not
diplomatie.
having apologies, but the sound that is reaching the translation booth is very bad. So apologies for that.
D'ailleurs, elle est en essor aussi en France, devant
The
le
number
nombre
of
d'affaires et de
cases is
l'augmentation chaque
growing
année, mais dans des limites politiquement
beyond the
acceptables. Et on le
limits
voit
of
très
what
bien,
is
nous, en tant
acceptable.
qu'avocats et société civile,
And
il y a une limite claire, je dirais, entre des dossiers qui sont qui n'ont pas de
they
conséquences
have
politiques ou
no
diplomatiques pour les
diplomatic
autorités
competence for French
françaises et
authorities.
qui eh bien, qui se
There's
déroulent sans
many
heurts et sans
obstacles
obstacles,
in
et puis des
problematic
dossiers
cases for authorities, and there we
problématiques
do
politiquement
see
pour les autorités,
many
où là, on voit
constraints. I'm
tous les
thinking
obstacles se
about, for
dresser sur notre
example,
route. Je pense notamment
the
aux procédures qui visent des entreprises pour leur responsabilité dans les
trials
complicités de droits
following
humains ou de crimes
claims
internationaux,
to big
et dans d'autres
companies.
aussi, là où ça heurte les intérêts politiques, on voit encore une
And
fois
in that
que c'est
case, it's
très
very
difficile
important.
de faire mener ces procédures à leur terme.
Merci
Okay,
beaucoup.
so I'm
Donc, je vais
going to
demander à
ask Grażyna to
Grażyna
come back
Baranoowska de
to
revenir à la tribune
the
pour
panel
des
to
remarques
give some final
finales, des
conclusions,
propos
please.
conclusifs. Yes. Merci.
So I was asked with the very difficult task to sum up not one panel, but 3 panels, that each of the panels could last for 1 hour. What I wanted to touch upon is only 5 points. So firstly, it hears from the contributions we had today that we do stand at a crucial moment. So we've heard there was a first case in Switzerland. We've heard about France. It was a first case in France. We heard about Germany. There's a huge change in the law. And then we are at the first Congress on enforced disappearances. So this is really a moment to discuss it, to change, and maybe also for hope, kind of to see where that goes. Then secondly, one of the reappearing comments was mutual assistance. So universal jurisdiction is not possible without cooperation between states. And here I wanted to come back to something that was said on the panel before, when the IIIM said they provided assistance to 300 proceedings in 16 jurisdictions. And I found that so impressive that states have created an institution that has the capacity of providing so much mutual assistance that then can bring change on the ground. So this is, of course, we have this institution only for Syria, but it really shows that those systematic, creative solutions can bring the difference and can provide the assistance that we need. Then thirdly, we've talked a lot about families and civil society. And I think almost every speaker said they are behind the change. They are really the ones driving, collecting the information, making all of that possible. And this was also very clear in your testimony that it was really it comes from the families. The one thing I would like to highlight here is that those families have rights. And according to the convention, they are also victims of enforced disappearances. And this is something that still really needs to be acknowledged in the proceedings. And we really need to give more justice to the pain and that the families go through and that are victims themselves. And this is still something for us to fight for and for the courts to acknowledge. Then a fourth point that I felt was reoccurring is there's not enough knowledge about enforced disappearances among prosecutors, among judges, but also among the victims themselves. Do they know that they can go with the case to court? So there's still so much to be done in awareness raising, and here we are at the Congress. I guess that's a good step also in that direction. And then the last point, I feel we said a lot of criticism, so it's clearly far from perfect. There's so much to be done, so much to be changed. There's so many failed trials of that, but they do give us a narrative. So it's really impressive to think we actually had a case concerning human rights violations in Belarus. Who would have thought that that's possible? It's amazing. We had actually at courts, we've heard about human rights violation in Syria. Isn't that amazing? We've heard that all over the world. So this is the narrative that those not perfect trials are giving us. And for that, I guess we are all connected here and are hopeful in good changes in that regard.
Thank you so much. This round panel has now touched its end. Thank you so much for the participation of the different members of the panel. Thank you so much for your contributions, for your participation, and also the attendees. Thank you for your questions. We need to continue working together to fight against impunity. Thank you so much.